Hello, and thank you for joining this webinar. My name is Monica Kanate, the Policy Manager at Access Lex Institute, and I'll be presenting today's topic on the current state of the law for emergency and other institutional grants. For those of you who may be unfamiliar, Access Lex Institute is a nonprofit organization whose mission is to increase access to and the affordability of legal education. We do this through policy advocacy, research, grant making, and student-focused initiatives. During this webinar, I will provide background information that will give you some context about how we arrived here. I'll then briefly discuss estimated financial assistance. For those watching who may not work in the financial aid space, I hope this helps you better understand this process. I'll discuss the professional judgment guidance that has come out recently. And finally, I'll tell you about some upcoming changes you should expect to see in the near future. First, I want to talk about how and why this has become such a prominent issue in recent years. So when the COVID pandemic began, we saw a lot of legislation attempting to address the economic impact that was being felt by institutions and students. Many of you may be familiar with the Higher Education Emergency Relief Fund, also known as HERF, that was created at the beginning of the pandemic. Congress provided this HERF funding to institutions with the requirement that a part of that money be given directly to students in the form of emergency financial aid grants for expenses related to the COVID-19 crisis. In addition to the funding provided by Congress, outside organizations also stepped in to help students. So, for example, in spring of 2020, Access Lex Institute gave law schools about $5 million in emergency aid to provide grants to students in need. The HERF funding that Congress provided had been granted a special carve-out in the law that exempted them from being considered estimated financial assistance. However, other emergency grants, like the funding that Access Lex provided, was still considered estimated financial assistance. And it was during this time that we started to hear from law schools about issues they were experiencing with dispersing this money to students. The reason schools were sometimes having issues dispersing the money was because of a rule related to estimated financial assistance. So what is estimated financial assistance and how does it work in the financial aid process? So in the Higher Education Act, or HEA, estimated financial assistance, EFA, is defined as the estimated amount of assistance for a period of enrollment that a student or a parent on behalf of a student will receive from federal, state, institutional, or other resources, such as scholarships, grants, net earnings from need-based employment, or loans. Emergency and other institutional grants, like the $5 million in funding that Access Lex provided, awarded to students are also considered estimated financial assistance. What's important to note is that a student's total financial aid award and other EFA cannot exceed the student's cost of attendance. This means that once a student has received total financial aid and other EFA up to their cost of attendance, they cannot receive any additional funding unless a financial aid administrator makes an exception using his or her professional judgment authority. So what is professional judgment, or PJ, and what does the guidance say? So before I begin talking about the guidance, I want to note that we've included a QR code so that you can access the Dear Colleague letter that I will be referencing today to take a closer look at the guidance. So as many of you are aware, PJ allows financial aid administrators to exercise discretion and provide for the individual treatment of a student who has special circumstances that aren't sufficiently addressed by the standardized federal student aid formulas and delivery methods. In other words, if a student has a special circumstance where additional financial aid is needed, a financial aid administrator can make an adjustment to provide the student with additional aid. However, because the percentage of students for whom an institution makes professional judgment determinations has been a factor that the Department of Education uses to select institutions for program reviews, Some schools have been reluctant or uncertain about the rules that allow them to disperse additional emergency grants. Because of this issue, the Department of Education provided guidance as a way to guide financial aid administrators through using PJ. The most recent Dear Colleague letter did 4 things. It reminded FAAs of their statutory authority to exercise PJ. It reminded FAAs of their ability to adjust financial aid eligibility based on a student's special circumstances. It noted that institutions using this ability would not be considered when selecting institutions for program reviews through the 2022-2023 award year. And it encouraged FAAs to use their PJ authority to reflect more accurately the financial need of students and families affected by the COVID-19 pandemic. The Dear Colleague letter also made clear that the Department of Education understands that some financial aid administrators are reluctant to use PJ because the department uses the percentage of students that an institution makes PJ determinations for as a factor for selecting institutions for program reviews. So essentially, the department is trying to make clear that they want financial aid administrators to use PJ and not feel hesitant simply because of the audits. To that point, on the Help Center section of the Office of Federal Student Aid website, there is a definition of PJ that underscores the Department of Education's position regarding a school's PJ decision. Specifically, the site states that the Department of Education does not have the authority to override a school's professional judgment decision, underscoring the deference that the Department of Education has for financial aid administrators making these types of decisions. There is also a QR code here on this slide for you to access that information. Now let's discuss some upcoming changes that you should be aware of. In a recent federal spending bill, several student aid policy provisions were attached, including provisions related to PJ. Specifically, the bill prohibits institutions from maintaining a policy of denying all professional judgment requests. It stipulates that during a time of a qualifying emergency, financial aid administrators may use PJ to zero out income earned from work if the applicant can provide paper or electronic documentation of receipt of unemployment, or can provide proof that an application for unemployment benefits was submitted. And it provides authority to financial aid administrators to adjust income earned from work for a student, parent, or spouse based on the totality of a family situation. Essentially, what's important to take away here from this bill is that the Department of Education will no longer allow institutions to not provide PJ. In addition to the previous guidance discussed, this also demonstrates that the Department of Education wants financial aid administrators to use PJ when needed. Please note that these PJ provisions do not have to be implemented by the Department of Education until July 1st, 2024. We have also provided a QR code here for you to access more information. So the last thing I wanted to highlight was our resources. If you want to stay in the know and be aware of what's happening in Congress and at the Department of Education, you can read our weekly Higher Ed Roundup that provides information on everything that happened in Washington that week. It comes out Friday mornings, and it can be found on our website or on our Twitter feed, which is AccessLex, INST. Secondly, please take a look at our Make the Case site that provides one-pagers on issues we care most about, as well as ways to interact with your member of Congress. We've also included a QR code so that you can access that site. Lastly, graduate and professional school administrators can join our Executive Policy Committee, also known as EPC. The EPC meets for a call quarterly to discuss what's happening in Washington, as well as get feedback about policy issues that you're concerned about. If you're interested in joining, please email me at policy@accesslex.org, and I will get you on our listserv and get you a part of those calls and get some of those resources out to you. That is it for today's webinar. Thank you so much for joining us. I hope this webinar was informative, and please feel free to reach out. If you have any questions, you can reach out at policy@accesslex.org. Thanks again and have a great rest of your day.